So Michael Kelly is still coming, but he's on his way from Cambridge. So what we'll do is we'll do some of the cases, starting with Nicholas B., that set of cases with school suspensions, etc. And maybe get into the Richard Ortiz hypothetical that I sent you guys last week. He should be here by 1:30, so we'll keep the class going until he comes. Hopefully he'll be here right on time. So, Nicholas B. School Committee of Worcester. Joe?
Nicholas had committed an assault off.
So who's who? It's interesting because, again, similar to some of the other cases that we saw on Tuesday, these are not really cases that came out of the juvenile court, right? So who sued who in Nicholas B. Worcester?
The student sued the school.
Sued the school committee, okay. So why? What had happened?
Well, he got expelled for something that happened off of school grounds. And
What was the something?
a battery on another student.
He beat a kid up, right?
Yeah, but it had allegedly started on school grounds.
Where was the battery?
Like a block away.
Okay.
So that was his first complaint, was that it wasn't on school grounds, so he shouldn't be punished for it.
That she should be punished. Is that what you remember?
I mean, yeah, for the most part, that's what I remember from it.
Somebody help him. John?
Well, yeah, he was expelled and then he was appealing it for...
Tell me more about that. I wanted to find out what was the scene at the school earlier.
He was involved in a scuffle earlier with his group of friends, and the victim's group of friends had a scuffle or that didn't amount to assault or anything. But they, wanted to fight after school, like kids do, and they did it down the street, off school grounds. They probably did it knowingly off school grounds, so they wouldn't get in trouble for that purpose. And he still got expelled because of the assault that occurred off the school grounds.
Yeah, and so what was the school policy for which he got expelled?
The school policy was if you are caught fighting on school property, you'll get expelled. So his complaint here is that he wasn't on school property when he committed the assault, therefore he shouldn't be subjected to any kind of disciplinary action, including the expulsion. Right?
And so, and Joe said that the cause of action was Nicholas suing the school committee. What kind of case was this? What was the specific cause of action?
The school's abuse
And it
of
was similar to
discretion.
some of the other school cases that we saw last week.
That the school didn't have the authority to do so.
Right, but Nicholas was suing the school for what? Under what was Nicholas suing the school?
The school's disciplinary rules.
What was the type of harm? What's the school looking for in suing in, whether it's in federal district court or this case ended up in the up to the SJC? case that went up on a shins or a delinquency. It's some kind of civil rights. He sued under the Civil Rights Act. It's a 1983 action. Keep this in mind when you do the Richard Ortiz hypothetical, right? So the school, so if you had to put, Joe, I'll come back to you, in a sentence, right, the rule, the proposition for which this case stands, right? How would you say, okay, Nicholas B stands for what? In the context of, juvenile rights. Okay, you guys thought Michael Kelly was studying right at one. I know it. What's the holding?
Judgment was affirmed, right? That
Well, that's a decision, but okay, so that doesn't mean anything. Judgment was affirmed, right?
well,
Put it in a sentence.
So a student can be expelled from school from
Keep going.
an action that resulted, even though he's off school property, the action started on school property. So I think maybe that's why the court affirmed it.
Okay, could somebody add to that or make that a little bit better than John just stated? Because it was the school committee that was sued, right? So put it in the context of the school and the school's action. Laura? No?
No, I can't find my notes. Sorry.
Remember when we looked at some of the previous cases, for example, like the actions of DCF in the Jeremy and Isaac cases, arbitrary and capricious language was used. It's used in this case as well. So the school's action, right, in imposing, so because that's what he was suing the school department for, right? For action that was arbitrary and capricious and was in violation of his constitutional rights. And the SJC ends up holding that, well, that policy, that action was not unconstitutional, it wasn't arbitrary and capricious, because as John just said, this was an incident that really began at school, that Nicholas B. really violated the rules of the school at school, didn't he? So then the question's going to become, when we look at the Richard Ortiz case, that might be one of the issues as well. All right, well, let's see who has the Pierce case. Can comment on that for us, the mistreatment of the American flag. Nicole?
Okay. So the father of the boy, Mark Pierce, was filing against the school because he felt that it was a constitutional violation for the boy to have been kicked out of school, and then the school had a meeting regarding it, and he just felt that the way the school handled it, it was incorrect. The boy ended up, he was really disruptive in school. He mistreated an American flag. He kept having suspensions for fist fighting and causing a lot of problems and ruckus in school, and they said that it was interfering with his educational progress. So they had a meeting in January and agreed that he needed to permanently be expelled from the school. So,
Why is this case important?
because it was how the school handled it. The parents said that the school had violated constitutional rights for the boy because he was kicked out. There was a meeting, and they didn't agree with how the school handled it. But the court, as far as I understood, said that the school did not violate anything and that they were correct in having that meeting and expelling him, and in the process of permanently keeping him out of the school, they were correct.
So going back to some of the student due process cases that we read having to do with the minimal procedural due process rights that are afforded when one is suspended. How relevant is that?
That's when like the students have to get like a notice, right?
Yes.
And they have a right to be heard. I don't believe he had that. I don't believe he really had a right to really kind of explain what happened. I mean, they said that it was a vote 5-1 that ultimately kicked him out of school. So that really didn't give him a chance to have his due process right.
Federal District Court upheld it though, correct?
Yes. Yes, they did.
So what's the rationale of the court then, Nicole?
It's highlighted. I'm just trying to find it. Oh, okay. The court said that there's the 5-1 vote of the school committee, which caused him to be expelled from school, was based on the grounds that he was insolent, defiant, disrespectful, and all of those other charges.
Yeah, so when it came to that point,
Yeah.
okay, what, you started to say, could you be more specific about all the things he had done sort of over a period of time, and all the teachers that had complained about him?
You want me to tell you what he did? Oh, he
Yeah,
had like
yeah.
fist fights, and he would, use inappropriate language, and then he mistreated an American flag. The science teacher also attested that he was a disruption in class with his, bad behavior, or whatever you want to call it. So they felt that this was such a blockage for not only his educational progress, but for other people as well.
What were the prior disciplines that he got for all of these?
He had a suspension.
How many?
He had several behavior cards filled out.
Mhm.
I think that's all they really did to him, though. Here, hold on.
How many suspensions?
A detention period imposed in October of 1970. That was the only disciplinary action imposed on him. In 1970, he had a suspension and then detention.
One suspension and one detention?
Yeah, as far as I
You
know.
sure?
Yeah, it's given 2 dates. It says only was a suspension in December 1970 and a detention period in October of 1970.
Wasn't there something about his entire high school career and how many detentions and suspensions he had received? He didn't have enough credits. Is that what you're referring to? No, just when the school committee had looked at his entire sort of career and sort of, we've had it by this time in terms of all of the previous disciplines that he had, amounting to X number of detentions, X number of suspensions, as you said, the cards as well.
Okay, here we go. From 1969 to 1970, he had 13 detentions,
Yeah.
14
Because you said
suspensions.
one, and I'm like, wait a minute.
Yeah, no, I was only reading the specific date I saw.
Yeah.
He had a lot of,
How many suspensions?
14.
Yeah.
So.
He was very, very busy kid.
Yeah.
So what does this case stand for, Nicole?
Well, basically, the school did take all the precautionary measures to kind of warn this kid before he was kicked out of school.
Mm-hmm.
But and the court recognized that, they really did try to help him, but it's ultimately he got expelled, and while his due process may have not been, completely fulfilled, they did try to, other avenues before kicking him out.
Yeah, and if you just mentioned his due process, so if you're going to do sort of a balancing test in terms of his rights and the school's duty, rights, liabilities, how do you talk about that?
Well, the school has a duty to, make sure that he's educated, but also for the children around him to be educated as well. And when it becomes a disruption and they've warned him, 14, disciplinary acts and then 13 of another one, that's disruptive to not only him but other people. So they need to they have a duty to kick him out at that point, remove the problem.
Okay, good. Anybody want to add to that? Okay, now we shift gears, and now we're looking at one of our first, actually, Massachusetts delinquency cases, because next week we'll get into the delinquency statute as well, Commonwealth v. Milo. That's the case with the interesting picture at the end, too, right? Michael, you want to do Milo?
Sure. So Milo, I believe he was 12. He was in the hallway of his class, and he drew a picture showing him shooting his teacher, Mrs. F.
Say that again, I'm sorry, I didn't hear
He
you.
drew a picture of his
Yeah.
shooting his teacher, Mrs. F.
Yep.
And while he was out in the hall, another teacher saw the picture and took the picture from the student and showed it to the teacher.
Yep.
A little while later, while he was still waiting for the principal, so I guess he had been in trouble before, he went back into the classroom, took another piece of paper out of his desk, and drew another picture. And then when he was done drawing that picture, he went into the doorway of the classroom and said to the teacher, you know, do you want this one too? And just based on the way that he was doing that, the teacher felt threatened. She had him give it to another student, and the student then gave that to the teacher. And then after school, that teacher, and I think it was the other teacher that saw the original drawing, they saw him like lurking around her car because he didn't leave the school grounds. So he was suspended, I think, for 3 days. And then after, he was brought to court.
How?
It was for a violation of, I think it was as a CRA. It was, no, it wasn't. It was a violation of 275 Section 2, it said. And
What does that mean?
it was the threat statute. And I guess it doesn't define.
So what court was he in?
He was in,
I'm sort of giving you a little bit of an introduction to your delinquency cases that we'll get into next week. So he was how old?
he was 12.
He was 12. So the jurisdiction of the juvenile court for delinquency cases used to be 7 to 17. It's just been recently raised to 18. And so the complaint would have been, I'm glad that you cited the statute, would have been, they're all delinquency complaints. So it's delinquency by reason of having allegedly committed a violation of the criminal law, a violation of a criminal statute, or a town ordinance as well, could be the subject of a delinquency case. So that particular statute was what?
It was 275 Section 2.
Do you know what the statute, what the crime was?
It was a threat statute.
Threats, yeah, threatening. Yeah, it's a criminal violation, it's a criminal statute that applies to adults and kids. So they're not directly charged with the statute like an adult would be charged with the statute. So that once, and the standard of proof is obviously the same. You're looking at the CRAs right now. Obviously, this is even more serious than the CRAs because they allegedly have violated a law of the Commonwealth. The standard of proof is beyond a reasonable doubt, just like criminal cases are. But the adjudication is not guilty like adults. The adjudication is delinquent. And his would have been delinquent by reason of violating that particular statute. What was his defense? What was his defense?
Oh,
Jonathan?
go ahead.
No, that she, I guess in the statute, it's supposed to, kind of like the normal threatening statute where the person being threatened has to have a objective fear or a reasonable objective fear that the person could actually carry it out.
Yeah.
And I think the court based its ruling that the teacher had a subjective fear that was reasonable.
Okay,
in regards to him showing her the picture, like, because he was saying that, you know, objectively, a normal person wouldn't be fearful of a 12-year-old who's drawing a picture.
okay. Good observation of the rationale, but you didn't answer my question. What was his defense? Jen?
First Amendment?
Yeah. So what was he saying?
Free speech.
Free speech.
What was the free speech?
Picture?
The picture, right? So think back to your free speech cases. Remember, we did the red ribbons. Articulate, if you were defense counsel, what would you be saying? You want to get this kid off, right? You want the case dismissed or at least no adjudication. So what's your argument relative to free speech?
That he's entitled to his feelings and that he was just expressing his feelings of anger towards his teacher for putting him out in the hallway.
At least use tinker instead of feelings. Remember the tinker case? Amanda? Oh, God, you guys need to review really soon. Laura?
Only because I found in my notes that schools can regulate freedom of expression if it causes disruption or disorder.
Mm-hmm. So how do you use something like tinker to argue he's got a First Amendment right here?
That he
And
would.
therefore, he doesn't really fall within the parameters of this delinquency case.
Because it wasn't disruptive or causing any disorder in the school.
How is it not a threat? And that's the tough part, right?
Right.
Yeah. So what are the arguments against?
Even saying it's not disruptive, I think, would be a stretch, you know, because the teacher is obviously upset by it, and that affects her ability to teach the other students, so.
And also think in terms of the climate regarding school violence, right? What sort of argument would you be making? Hey, we haven't done a little changeover, right? You guys used to represent child, right? This side. Let's, starting next week when we start the delinquency cases, actually we'll just split into two this time. Commonwealth and juvenile, so I'll split you this way. Up to John for next week, and thereafter the delinquency cases that we do, you guys will represent the Commonwealth, and then from Laura down, we'll represent the juvenile, okay? So, you Commonwealth people, make an argument, using policy more than anything in terms of school violence.
Well, wasn't this decided around the time of Columbine? I think it was in 2000 or 1999 or something like that. And I think that was there was an influx of school violence around that time. So to allow students to be able to draw pictures and to know, and to not only draw pictures but to know that that type of behavior would be protected, could possibly have some public policy issues and concerns as far as, you know, influencing school violence.
How about arguments with the child on this side? Could you concentrate on his age, perhaps? Michael said he was 12.
You might be able to,
Go ahead.
because he's so young, 12 years old, like, I don't think he is even old enough to comprehend the consequences of him drawing this picture. I think it was just to get it off his mind and draw it, but not necessarily, you know, be able to carry it out.
So suppose that, let me ask you a question. At the beginning, Michael, when you were first struggling with, oh, Milo, I have to do the Milo case, and you said, I think this was a CRA, and you said, no, not a delinquency. Could the school take out what used to be called the chins, a CRA on a kid like Milo? Now, think back to the Brasher and the other cases that you read last week and the statute and the 4 ways you get into court on a CRA. This delinquency is much more, you know, obviously serious, if the school were, more like concerned about him, let's try and help him, short of having, a criminal delinquency record, but we think this merits some sort of serious, help. Could the school take out a CRA?
I think maybe they could.
So
Because
what,
one of
Yeah,
the
but-
four would be like disobeying the school orders, like whole violence and
the
threat.
school, could the school take, and that would be the only one that would apply, obviously, it has
He
nothing
didn't
to do
run
with
away.
running away or disobeying at home or being truant, so could the school take out a CRA for the school offender piece and, look back to what the statute requires as an element of CRA? Michael, you look
Well,
like.
I was gonna say, it would depend on how frequently he's been in trouble. I think if it's one sort of isolated incident, then you can. My understanding was it was based on habitual behavior that you're.
What's the language of the statute? I think I've got it. At one time it was persistent, and another time it was willful. So we want to look at 119. Here it is. So 119, 21, which was in your definitional section as well. Repeatedly fails to obey the lawful and reasonable school regulations
Right,
of the
so-
child's school. So that's what you're getting at.
I think if you
It
don't have-
isn't conduct that, but then what do you do? I mean, other than, they charge this 12-year-old, as Amanda was saying, kid, with violating a criminal statute, and he might not really understand, does he really have the mens rea for something like that?
I don't think he does.
I don't know, how old was that kid that went on the stabbing spree?
Yeah. Good point for the state.
I wasn't trying to.
He's always
I was really literally just asking the question. It wasn't hypothetical. I think he was pretty young though.
Yes. Yes.
Right about the same age.
I thought he was like 12 or something.
Yeah, you're correct.
It's that very awkward stage when the kids are going through puberty, hormones,
Absolutely.
but they really don't have the full mental capabilities of
Mhm.
understanding what all their consequences are. And nowadays, with the types of video games they play, and they just think like,
Mhm.
oh well, when I killed the zombie,
Exactly.
I just respawned and like life went on. It's they have sort of a warped perception of the real world.
Mhm. Jonathan?
I don't think in this instance it would be advantageous to have the reasoning be surrounded around the child's mens rea, I guess, because the fact of the matter is, like Joe said, he has the ability to carry it out. So it's irrelevant whether he understands it or not. The point is to try to prevent that type of thing from happening. So in allowing this type of thing to be in the schools, it's regardless of whether he understands it or not, or whether he's too young to understand it, it would make it more likely that that type of thing could happen.
Would it matter, or how would you vary these facts? How do I say this? Suppose that, if we needed to know more about Milo, is there a set of facts that would warrant then a CRA, where the CRA says, you could have to have basically more than one instance. So what would you need in terms of more facts about Milo to, allow the school system to take out a CRA rather than bring the police in and, have a delinquency issue against him? You know what I'm saying, Laura?
Wouldn't you have to tell him this was unacceptable behavior, and then, so it was a lawful and reasonable command, and then he disobeyed that lawful and reasonable command, and then he gave her these
I
pictures?
guess what I'm asking is, would you need more instances of other kind of conduct
Or the same.
You know what I mean? Before
Yeah.
he did this, was he, like the kid, the case that Nicole just talked about, detentions, other issues with Milo, before the school sort of said, oh, we're raising our hands up, we need, the juvenile court to help him. Let's see if we can have him declared a child requiring assistance, so that as a prophylactic sort of step, before he ends up, committing, really serious crimes, the whole school to prison pipeline sort of argument. So what would you need to see? I guess what I'm asking is, what would you need to see in terms of facts to warrant the school being able to not only file but sustain without dismissal a CRA application?
Well, if he's made other threats, like there's other teachers or other students, either verbally or in writing.
Okay.
If there's been other times when he's been disciplined for other things and he, was told not to do something and he did it anyway, constantly in trouble.
What if the school did, Jonathan, go ahead.
I have a question. What if they open his locker and then he has a flip book with every teacher in there?
Yeah,
that
like a
he,
hit
wants
list
to shoot?
Like hit list.
Not a hit list, but it just has just a bunch of pictures. And he's just shooting every one of his teachers. That's one instance. But could that be zero?
Would that merit, yeah.
That's what I was
And I
wondering
guess my
about.
question was then gonna be, so suppose the school went anyway on this? Went to the clerk's office, right, and said, I wanna take out a CRA. There are avenues available then, right? Informal assistance through the court system, probation office, without actually having a CRA taken out. That supposedly, is the crux of this new statute, getting, it talks about families requiring assistance as well. So, his conduct at school could also be a direct result of something going on in the home. Remember, we also mentioned that there's overlap in all of these cases. So you could have Milo, who's acting up at school, who's being neglected or abused at home. And not only is he acting up in school, violating school rules, but he's also committing a criminal violation, thus holding him open to a delinquency complaint. So you could have a fact, again, we're getting close to exam time. You could have a fact pattern that's one kid,
Dealing with
and it looks like it's real clear that it's just a delinquency, threatening, it's this particular statute. But then if you're told about more facts regarding this kid, and how many mandated reporters are out there in terms of neglect or abuse, etc. Did anyone read the Richard Ortiz hypothetical?
Mhm.
Yes, okay, so,
Can I just add
Yeah.
one thing that was, I
Yeah,
think,
add.
important to point out on that other case was one of the arguments that the defendant was making was that he didn't have, the court couldn't show that he had the ability to carry out the threat, and that was part of the requirement was that the threat was, made to the person and that the intent was there to do the act and that they had the ability to carry it out. And the court said that, basically there was enough other evidence, circumstantial evidence to show that he had the intent, the whole waiting after,
yes.
I just thought that was important to point out.
And it's key that the court, the SJC says that this was sufficient. You hear a lot of cases talk about the sufficiency of the evidence, that this was sufficient evidence to support his adjudication for delinquency. So my overall question in the Richard Ortiz hypothetical was, if you suppose that you were counsel for Richard Ortiz, and it's a child requiring assistance case, and how would you advise Richard as to his rights in the case, based on, can somebody give me a sort of description of at least the facts. Refresh our memories for those that have read it. Anybody want to tell us about Richard? Jonathan? Can you tell us about Richard?
Well, I'm trying to pull it up, but if I can go off of memory, it was a kid who was bullied, and I think.
So in what way? First of all, what do we know about him, his past, and how he came to school? And
I don't remember.
I think he had just moved here and one of his friends.
so Amanda said he had moved here earlier, recently, I'm sorry.
Recently.
And who died?
I think wasn't one of his friends, didn't one of his friends die?
How?
He was beat because he was gay? I
Yeah,
think is that right?
yes, okay. And so, Jonathan, do you remember some of the incidents that occurred in school? Shortly after Richard starts.
I guess like there was a couple of kids who had cornered him, and
Where?
What was that?
Where did they?
Off of school grounds.
What's that?
Off of school grounds, or like
Can you talk about the gym incident first? When you said court.
the gym incident.
Does anybody remember that one? And you could do the off-school grounds one. What's the gym incident? John?
Some kids were telling him to go in the girls' room, and
Why were they telling him to go to the girls' room?
because they were picking on him, they were just bullying him because of I don't know, I forget if he had feminine qualities or not.
Mhm.
But he defended himself by grabbing a hockey stick and beating them up, or
Beating who up?
the kids that were making fun of him.
All?
2 or 3 of them,
So he hurt 2 or 3 of them?
I believe so. I'm going off memory too, I can't
I
find
think he
it.
hit one of them.
He hit one of
He
them.
hit one of the boys with the hockey stick,
Yep.
and then after that, he threw.
So what happened to the boy that he hit?
He broke his nose.
He broke his nose. You should be thinking now, okay, assault battery. Keep going. So that was that incident, and so what happened to Richard? Did anything result as a result of that incident, Laura?
He got a detention
He got a detention.
for that, yeah. And then, as he was walking home from detention, some of those same boys followed him, and they were calling him faggot and queer. And then he threw a brick at them, and they ran off. And then, in addition to those 2 incidents, in the first 2 weeks of school, he's been verbally harassed dozens of times in the hallway.
He was harassed, he didn't
Yeah.
harass others, you're saying, he was harassed.
Being
Yeah.
called fag and queer by both boys and girls. And none of it's done in front of the teachers. It's done mainly in the hallways, in gym class and after school. And then when he strikes out, that's usually visible, and then he gets in trouble.
Can you go back to the discipline he received and describe that, the in-school
So,
suspension?
so after he threw the brick, he got I think it was a week, in-school suspension. And in he was supposed to write an article, he was supposed to do research and write an article
Right.
about, I think it was about, I can't find the exact word, but I think it was about violence, related to school violence.
Okay.
And so he didn't write an essay at all, he scribbled at his desk and everything, and then in the end he turned in a list, and it was devoted to what teachers and administrators, not students, should do about school violence. And then they immediately called us home. When the teacher took it to the principal, they immediately called us home. They wanted a conference with him. He didn't show up to the meeting.
Who did?
His mother
Yep.
did. She said he wasn't feeling well. And then she also said at that point he was about to be involved in a gang.
And again, okay.
Yeah. And, you know.
Can you go back to that list?
Yep.
What, Jonathan?
It's makes fun of me.
No, she was making a lot of noise.
Oh, okay, blame it on Jennifer.
Yeah.
Right.
What do you say in the list that really got the school sort of going?
It includes mostly things teachers and administration do.
Laura, I can't hear you.
Oh, sorry.
Oh, here comes Michael, you're all safe, because we've been plodding along, because they didn't really do much for today, because they thought it would be. No, it's not your fault, this is Michael Kelly, guys. Do you want to stand, do you want to sit? Come stand, come sit on the stool. Oh, do you know her?
System going on in the corner?
Oh, yeah.
Yeah.
That's all right, Anthony Gagano really did a number last week, the week
Oh,
before.
good.
Yeah.
Good.
And I said, am I being taped?
So I apologize, I was in Cambridge Juvenile Court this morning, and as will want to happen sometimes, one of my clients that I had on a totally different matter was arrested last night, so I had to stay there and figure out
So
what to do with him
was it a
today.
CRA client?
It was a
that-
CRA
Oh, tell
client.
him about it.
Well, he's had a lot of problems for a year in school and at home. He is, it's kind of an interesting case because he and his family are from Bangladesh, and so I didn't know that much about that culture or that country. But they've come here to make a better life for themselves, and he has a hard time adjusting, and probably is using marijuana and alcohol and other things, and having difficulty in school because of that, and trying to make his way and figure out his way here in this culture, in this society. So Sunday night he had a little too much to drink, and I think one of his friends convinced him to break into a gas station, see if they could get some money. But he didn't get very far, except he busted up his hand, I think, and that was about it. But of course, the gas station had a video camera, so the video camera kind of caught everything. So I don't think I had much to defend him on, because they kind of found the sweatshirt that he was wearing and a pretty good ID. So we'll see what happens. So he had never been arrested before, so he was released, allowed to go back home, but we have to come back next week and see what we can do to help him some more.
What's the status of the school offender
The
case?
school, it's the CRA was filed by his mom, so it's
Oh, by his mom.
stubborn
Oh.
case. But along with that,
Mhm.
having a lot of problems in school. Part of what the mother is upset about is
Okay.
that he's been having so much problems in school. So on my way up in the car, what I was thinking, and something that I teach new lawyers as well, is that sometimes the case that brings the juvenile to the court's attention first is sometimes it's like an accident as to what case gets them into the courtroom first. They might get arrested for something first, or if their parents are on the ball, their parents might bring them to court for a child requiring assistance case, and that might be the first case that the court hears about them. Or if their parents are not on the ball, it might be a camp protection case that gets filed, right, after a 51A's been filed against the parents. And so it can be, it can almost be, I don't know that accident's the right word, but it can be kind of fortuitous as to what kind of case gets filed first. And often, depending on what case gets filed first, someone may have to file a different kind of case if it's really a different situation. And it's almost, the juvenile court is usually flexible enough that no matter what kind of case it is, they can try to get help for the juvenile and for the family. I mean, it's important what kind of case is in front of the court, because that determines what powers the court has to do things. But sometimes what gets filed as a CRA may really be a care and protection case. What gets filed as a delinquency case might really be a CRA case. A lot of the cases that I've had recently are domestic fights, arguments between children and their parents. Sometimes
they filed
between
as-
siblings, sometimes, and sometimes the parents will call the police. And because because the police now have policies where they have to arrest anybody who
Calls.
commits an assault and battery, and if there's visible injuries, and if there's other things, they treat them like a domestic violence case. Somebody gets arrested, so it's a child. Where it really is more of a CRA case or a camp protection case that really should have been brought earlier. And so one of the things, how many of you have been following the Jared Remy case? Jerry Remy's son, his Waltham District Court was brought into court for beating up his girlfriend, and the DA didn't ask for him to be held. The judge let him go, and then a day later he killed the girlfriend. So there was a lot of controversy over that, but because of that, the Massachusetts legislature is looking to make more strict domestic violence laws. But one of the unintended consequences of that could be, depending on how they do it, what always happens is when you create this law is that the devil is in the definitions that you use. What does it actually cover? And the definition of domestic violence can be really broad. It's not just boyfriend, girlfriend. So it could be
Mother-son.
mother-son, brother-sister. And if the same definitions are applied to that, do you lock them up? So it's a difficult question. So when I've come to speak at Professor Collins's class before, and I try to think before I come of what in particular is new that is coming up either in the juvenile court or in the probate and family court, because that's kind of what's most interesting to me and what I hope is interesting to you. And one of the really exciting things that we probably have talked about in class is that the age in Massachusetts for juvenile delinquency has been raised to 18. Historically, for 100, 200 years or whatever, the criminal law in Massachusetts treated a 17-year-old as an adult, and that had never changed, had never been fixed, had never been either decreased or increased until last September, when Governor Patrick signed the law into place that raised the age from 17 to 18. So what's happening now, when a 17-year-old gets arrested, brought to court, they're being brought to juvenile court rather than to adult court. And that's just a really good thing for them. Not have to go to adult court, not be treated like an adult criminal. And they get to, their cases come to juvenile court, and they get to be heard there and get the benefits of that. So that is coming into place, and it is really good for those people who have those kinds of cases. The other thing that was a big change, which is now a year and a half ago that it went into effect, was the change from the CHINS law to the CRA law, the Child Requiring Assistance law. In a lot of respects, it just changed the wording of the law and what they call it, but it did change some of the procedures in court to make it a little bit better. And what was supposed to happen along with the changes in the courtroom was that there were going to be more services for the children and their families.
She said supposed to.
Right. Well, they made the law changes right away, and they gave the state a couple of years to put the additional services in place, because it will require money and so they are working on that, trying to get it in the budget for the next fiscal year that begins July 1st. So I think within a couple of years we might see, they're going to call them family resource centers. They will be
In the
different
courts
places,
or
in the community.
in the community?
They might be attached to a school center, they might be attached to a DCF center that's out there. but places where families can go in the community to get counseling, get some help, get some referrals. And so the theory is that before a family would come to court for a CRA case, they would have to go to this center and see about getting services and making it maybe a little harder for schools to file truancy cases, because the school will have to say, we brought the family to the center, we tried to get help in other ways, we had the dropout prevention program that we tried, and so kind of making court more of a last resort rather than a first resort in COA cases. And then in the care and protection world, of course, the issues that have been in the newspaper about that are all of the issues regarding the terrible case in Pittsburgh, where DCF lost track of the little boy. And the DCF social worker was supposed to be visiting her every month, and they were either making it up or just lying about going to see him. And the social worker, the supervisor, and the manager all got fired. And now every case where DCF is at all worried about it, they're filing it as a care and protection case.
Yeah.
So the number of care and protection cases has gone way up in most courts, and the social workers are overwhelmed, and everyone has to document everything that they do to every great extent, and so there's a lot of overreaction to that kind of thing. So it's interesting to see if anything changes. We've been doing this kind of work for so long that we've seen these things happen many times.
Michael, could you explain to the class the steps from the, going into court with the intent of filing a CRA through like disposition?
Yeah,
Like,
under
what is
the
it?
new law, assuming it's a parent that's coming to court saying that their child either doesn't obey them or runs away from home, the clerk is supposed to offer the parents some services, some help, referrals, ask the parent if they want to try that before they actually bring a court case, depending on what the parent wants to do. If the parent wants to try a court case, file a petition against their child, then the case is scheduled within 15 days to see the judge. Because the judge and the probation then decide, is it a case that needs to be a formal case in court, or can we try to help the family informally? And they can help the family informally for up to 6 months, and then the judge has to decide either to dismiss the case or to make it a formal case. Once the case becomes a formal case, at whatever stage, then the judge, kind of the first thing the judge has to do is to decide, is this really a child who has run away, hasn't gone to school, hasn't obeyed their parents? Is there some meat to this case? That's called the fact-finding hearing. And that used to be, you used to be able to get a jury trial for that.
Yeah.
No one ever really did it, but theoretically it was, but they've done away with jury trials. So it's a bench trial in front of the judge, and the judge decides if you qualify under the law as a child requiring assistance.
We were talking about how weird that can be, where in most of the cases, the only attorney, short of
Right.
the parent's attorney, in
Right.
those cases, is the
Right.
child's attorney.
Right. Although part of the new law and part of the case law, it gives parents court-appointed lawyers in more situations.
Yeah.
So it's a little more common to see multiple lawyers in the courtroom now, because you may have a lawyer for the child and a lawyer for the parent.
When does the lawyer for the parent get appointed?
They get
And
appointed.
is it just Hillary or the statute as well
It's
now?
both now. It's the
Okay.
statute as well.
Hillary's the case you
statute
guys just read.
provides for appointment of counsel for a parent when there's a question of whether the child is going to be in DCF custody or not. I forget the exact wording of the new
So, yeah,
statute, but
yeah.
basically
Where,
it's whenever there's a possibility that a child might go into DCF custody. So it could be after the fact-finding hearing and you have a disposition, and the disposition could be DCF, or it could be early on if there's an emergency that might require temporary custody of DCF.
so what typically would be an example of something like that?
Well, an example of an emergency would be a situation like the one where parent and child had a big fight,
Okay.
or a big physical confrontation, such that it's felt that the people, they're not safe. Could be very severe substance abuse on the part of the child, where the child might need drug treatment or something like that. And so if it's, or it could be that the child's been arrested for a very serious crime, and the judge doesn't feel comfortable letting them go home. By the same token, they may not need to be locked up in UIS detention
For the crime.
for the crime, but maybe DCF would have an alternative program that they could go into. And that is sometimes done on an emergency basis instead of having to lock juvenile.
And when you say emergency, do you sometimes see like it sort of like on the same day, okay,
Yeah,
we
can
need
be
to have a
the same
second
day.
call and
Yeah.
we need to find an attorney to represent the parent, like
Yeah,
right now.
We need the social worker here now, we need everybody here today. It's an emergency if the child is there under arrest or in the lockup, then we have to see what the best place is for the child to go to. And in an emergency, the judge can place the child in DCF custody for up to 2 weeks. And then they have to come back to court and make a more permanent decision.
Instead of just having the child go to DYS, can't they go to like their aunt or a
Sometimes, yeah.
friend?
Yeah, definitely. Sometimes you might need a CRA case to give the judge that authority to grant custody to get DCF involved in making that placement. Sometimes it can just be done when they do it in some cases, but yes, there's lots of options, lots of alternatives that can be put in place.
I know it's still a fairly new statute, but do you guys, do the judges, the court system, the lawyers like the language?
It has some pluses and minuses, it's like anything else. I think we're all used to it now, so we kind of know how it works. In a lot of ways, it hasn't really changed from the Chim's law. The one thing that is in certain situations, the time frames are much stricter and more defined. So that the temporary custody can only be for 2 weeks. The informal can only be for 6 months.
And what happens, so if it's informal, and then you're getting close to the 6 months?
Yeah.
What can happen?
Well, it has to come back before the judge, and the judge either has to make it formal or dismiss it.
Okay.
The biggest change is probably that once there's been a disposition on the case, whatever that disposition is, the judge has to review that disposition every 3 months.
And is that the
But the new
Angela?
law, no.
No, okay.
Angela says how that review has to be done. But the new law gives the time frames, so there can only be 4 extensions of that disposition. So basically, after the disposition, you have a year
Every 3 months, 3 times, okay.
to give the child and the family services, and at the end of that time, the case has to come back to court and be dismissed.
Even if the child still has issues?
Even if the child still
the
has
family still-
issues, so you may have to file
A new-
another CRA or a care protection or make some other arrangements, find a relative, do a guardianship, find some other. But the theory of the new law is that it's a short-term intervention. That it's not going to last forever and ever. There were rare cases where, under the CHINS law, you might file a CHINS when the child is 12 or 13 or 14, and if the child could never go home, they might stay in DCF custody until their 18th birthday. And that's not really what it was intended for. So the new law says you can have it for a year. At the end of that time, it gets dismissed. So that's probably the biggest change. So you really have to be thinking all the time that this is a short-term, hopefully intensive help for the child and for the family. It's not going to last forever and ever.
And we had also been talking a little bit about the courts, you know, what the court can and can't do, court's authority in terms of some of these cases. So what are some typical dispositions that are within the court's authority?
Well, for a CRA case, the most severe thing that a judge can do is to grant custody to DCF and take the child out of their home
Yeah.
and order DCF to place them somewhere else. DCF has not a lot of placements for teenagers, especially for older teenagers, so it could be, and so they
So
don't
what
have a lot
happens?
they don't have a lot of foster homes, especially with teenagers. So occasionally a teenager will get into a foster home, but if not, they could be in a group home, it could be in a shelter facility of some kind, they could be in a residential facility of some kind, and all of those are private facilities that vary tremendously in quantity and quality, and some of them can be very good, and some of them can be not so great, and it also, they all come in different types, so some of them can be short-term, some of them can be long-term, so one of the things that can happen is that kids can be moved a lot. They may not be very stable in where they're set to live, so if you can come up with a relative, often that's a much better alternative than having them go through different places with, that the state has to offer. And the other element of that we're seeing a lot more emphasis on for the lawyers is to be on top of what school the child is going to. Because if they're taken out of their home, given to DCF custody, they can be placed anywhere in the state. Even some of the placements are in New Hampshire. They can be,
Right.
it could disrupt what school they're in, which is kind of against the whole purpose of it as well,
Exactly.
is you want to maintain them. So there are some federal laws now and state laws that try to help them stay in the same school. So you have a lot of kids being bused from a placement back to their school, but at least it maintains their connection to their school and their education.
Speaking of education, we used to have, remember the educational GALs, and now we don't. So do the CRA attorneys do a lot of school
Supposed to,
stuff?
yeah, supposed to do a lot more. Even the delinquency attorneys are being asked to do a lot more school things, because depending on what the charge is that the child has, they
Right.
sometimes will be suspended or expelled from school.
Yep.
And the lawyer has to get in there and fight back. There's a lot of school advocacy, so a lot of what we're being trained on and being work on is a lot of school law. So we have to know and be able to deal with that a lot. Because the biggest part of a child's life is one part's home, and the second biggest part is school.
Right.
And that's really what their job is, to get school, and with all the emphasis on not dropping out, passing MCAS, they need to be in school, they need to be learning. there's a new law coming into effect on July 1st that is going to require schools to give students alternative education. So even if they are suspended from the school that they would normally attend, they need to be offered some kind of alternative.
By expulsion
Yeah.
too,
Yeah.
because you just said, okay. And who picks up the tab if,
Don't know. It could be an unfunded mandate. You know how much
like many are.
people like those, yeah. So again, as you'll see, when you look underneath all of these laws and all these services and what's going on with kids, what you see is the financial underpinnings
Right,
of it.
I know.
And who's paying for it, what are they paying, how much are they paying, and so a lot of the problems in DCF are that they, when the recession hit in 2008, their budget was slashed.
Yeah.
So they don't have as many social workers, they don't have as many foster homes as they did in 2008. So you hope that a social worker isn't losing track of the child, but by the same token, every social worker now has twice as many cases as they should. So it's kind of foreseeable that the work is not going to be of the same quality as it might have been before, and they don't have as many places for kids to go and help the kids to get. So it's kind of understandable that things might fall out of this. And the other piece that is always a challenge is figuring out how to get mental health services for children. So they can be in school, they can be at home or in a placement, but if they have mental health issues, there's a real problem getting good mental health services for children. For children that are on mass health, the state has, by a federal court order, put more mental health services in place for children that are on mass health, on Medicaid. And so there are some more services in place for them, but in a bizarre twist of fate, it means children who have private health insurance sometimes don't get as good mental health services. Because then you're relying on Blue Cross or Tufts or Harvard Pilgrim to pick it up, and they have restrictions. And so there's problems. I just heard a horror story recently that there are a lot of children every night who have to stay in the emergency room of a hospital because there are no hospital beds for them to go to. So you have children waiting in emergency rooms for a hospital bed to open up. And then what was happening a few years ago was that the children, when they got into a hospital bed, could never get out because there was no next place for them to go to. All of the next places were full. And they had to wait till one of those opened up before they could get out of the hospital. So you had a lot of kids stuck in the hospital that had no place to go. And they would be sitting in the hospital for longer than they needed to be because there weren't enough beds further on down the road for them to go to.
You mean as far as like a mental health
Yes,
commission?
yeah. If they weren't ready to go home yet, but they didn't need to be full-time in a hospital, you need some kind of halfway.
It's the same it's the same with adults. I
Yeah.
work at a hospital.
Yeah.
That I
Yeah.
would say on a daily basis,
It's
there are people
terrible for
helping.
adults, but it's even that much worse for a kid. I mean, adults have hopefully a little more resilience sometimes, but imagine a kid having to sit in the emergency room or having to go to a hospital and then sit there for a while, so it's very frustrating. The services can be expensive to offer and to get involved.
How does your role your role as children's counsel, do you perceive it to be different, because we'll be getting into the delinquencies next week, in CMPs, CRAs, delinquencies?
It's a little easier in a CRA or in a delinquency because the children are predominantly older, and your focus can really be on representing the child, what they want. You're able to explain things more, and you're able to, and your job is to represent them as their lawyer. They're your client, and even if what they're saying doesn't make a whole lot of sense, your job is still to say it to the judge as best you can.
And many times it doesn't make
And many times it doesn't make sense. But I mean, the other side of your job is to be the counselor to your client, too. And to give them advice, explain everything to them, make sure they know all of the possibilities, and then hopefully you get back from them maybe something that's a little better after you've done all the explanations and everything else. Care and protection case, you'll sometimes get a much younger child that's very harder to represent because they can't tell you. If you represent a baby, it's kind of hard for the baby to tell you what they want. But we're instructed to use our best judgment to essentially do a substituted judgment for the child. If we were in the place of the child, what do we think the child would want? And we're supposed to fight for that. And it's different, and it can be different from what's in the best interest of the child. That's for the judge to figure out. Judge figures out what's best for
does
the
a
child.
GAL.
There's a GAL, or GCF might be arguing, but all of it's an adversarial system where all the parties argue for what they want. And then the judge distills all of that and figures out what he or she thinks is best for the child. But our job is to advocate for what we think the child would want. So even in a tough case, if we think the child would want to be home, that's what we need to argue for, even if maybe that's not the best thing for the child. But most children, even if their families are not that great, they want to be home. Because that's their family.
Anybody else have questions? I've been asking a lot of questions. What you want to know about?
How long have you been doing it, and what made you go into this
Oh,
field?
God.
No, it's a good question. I've been a lawyer for 30 years, and when I started out, I did very general practice, just about everything. It was a little easier then to get cases because they didn't pay you anything at all. Now we get the princely sum of $50 an hour or $60 an hour, but back then we were lucky to get anything. But it was work and it was out there. So at the beginning of my practice, I did criminal adult defense. I did all sorts of family law. I did civil cases. I did just about everything. But as I went along, I just gravitated to doing the juvenile cases, the care and protection cases, and the family law cases. So I do a lot of probate and family court work as well as the juvenile court work that I do. I just found, to me, it was really interesting, really. It just brings in so many different areas of law and of psychology and psychiatry and so many things that I needed to learn, and so many things that have to be factored into all the different cases, that it's just, every day is really interesting to me. And I just found myself liking that more. I mean, I did doing adult criminal defense. Some people love to do that and they love it every day, but there were so many OUI cases that after you've done like a few of them, I really didn't want to do them anymore. And there were so many domestic violence, restraining order cases that after you've done a few of those, you get really tired of them. I did. So I found this But over the years, it's changed a little bit. I'm probably doing less child protection cases now and more delinquency cases. They're a little more cut and dried, a little more in and out. The child protection cases can go on and on.
Tell the class who pays you and how.
The Commonwealth of Massachusetts pays. They pay, as I said, $50 an hour for most cases, but they pay pretty well every month. You get to submit a bill. It used to be you could only bill at the end of a case or once a year, and then they made that you could bill every 3 months. So that was a vast improvement. Now you can bill every month, and the cash flow is a lot better than it used to be. Unless they run out of money at the end of the fiscal year, and then you have to wait. But that hasn't been too bad recently. So.
And you have to be certified initially and then do continuing legal ed.
Legal education, right. You have to be certified initially, take a big training class, and get qualified to do the kind of court-appointed work you want to do. And each type of case is a different training. So you have juvenile delinquency training, you have child protection training, there's mental health training if you want to take the mental health cases, like you have the adults who are being committed or sent to the hospital or who are under guardianship. There's separate trainings if you want to do appeals. Some of the cases that you've seen my name on are the child protection appeal cases. So I'm certified to do those. I have another one coming up on May 1st.
You do?
Yeah,
What kind of case?
bad. I represent a father and he's got no case, so a
Oh.
lot of my appeals are pretty sad.
You're not gonna make new law?
Not
Some
gonna
of
make
your other
new law,
cases?
no. And if it does, it will be bad new law. So we try to keep away from those.
Because they all have a right to appeal. And
Exactly.
that's, you know.
Exactly.
So
You have a right to appeal to the Supreme Judicial Court, and you have to do
do
it.
you have your own private office still, or
Yes,
you work?
I do.
And then, are those cases sort of like, does the clerk contact your office and say,
Yes.
hey, we want to appoint you to this,
Yeah.
or?
Yeah. Or in some situations, you might get a duty day where you go to the court, and any cases they have that day, you would be assigned to. Like the appeal cases, there's a central office in Boston that is the gatekeeper, and when they hear about an appeal, they go get the lawyers for that kind of case. So they'll email me and say, can you take an appeal? And I'll say yes or no. So each case is slightly different. The commitment cases happen so quickly that they sometimes, I think they call you with those. They actually call your office and say, are you free to do a commitment case tomorrow?
Yeah.
Kind of thing. Because there are emergencies. But a lot of the cases that I do, I would be in court doing what's called a duty day. So I would be there available to take any cases that come in that day.
I think we're out of time.
Yeah.
Thank you so much.
Thank
for coming.
you.
Thank you.
Sorry I was late.
New last year,
Yes.
right?
And the new school.
Oh, yeah?